until you see how the judges work. I would kind of liken this to the workings of a ship. You know, you can't. When you're on a ship, you're just going from here to there. How it gets from here to there, and how that bridge works, and how that engine room works, and how all of the crew members work, is an experience that maybe only a seaman can really understand or appreciate. And this thing of law is an interesting, thrilling, and it's exhilarating. In fact, it gets to be so much fun. Our students oftentimes will just go out and do what we call baiting bears. And I'll cover that at another time, but bear baiting is, it's like recreation. It's like sport. You go out and you bait this policeman into giving you a ticket and try to see if you can get him to violate some civil or constitutional rights so that you can go into the court and argue a case. I mean, after all, how are you going to get in the courtroom unless you've got some tickets or something to argue? Now, what we're talking about then, I try to spice this up and tell you a story once in a while to make this interesting, because probably in the minds of most people, nothing can be more dull and interesting and less exciting than this thing of law. And boy, I'll tell you, the way it's practiced by lawyers, it is pretty dull, dry, and uninteresting. But when you're operating in the courtroom and the adrenaline is flowing out of your own heart or into your own heart, and you're the one that's on the line, and you're the one that's charged with the crime, and you're going to go to jail for 30 or 60 days if you lose, let me tell you, that puts a lot of interest into this, and it puts a lot of interest in a hurry. Now, the courts are not interested in putting you in jail. The lower courts, the traffic courts, are interested in making money. Money is the name of the game. Putting you in jail is a little extra frosting that goes on top when they have bed space available. But they don't want to put, basically, clean living honest citizens in jail. They just want to keep you going through the criminal justice system. Tickets, yeah, they'd like to give you 2 tickets a year for $40 a piece, and they're collecting $80 a year off of you. That'd be perfect. You come in, plead guilty, tell the judge why you're a bad man, pay them the $40, leave the courtroom, do that twice a year, they'll love you. There isn't enough jail space to put everybody in jail, and so they want to reserve that for special and needful reasons. But on the other hand, they don't want too high a vacancy rate. Anybody who's in the apartment business is going to understand the vacancy rate in the prison, the vacancy rate in the jail. You know, you've got to keep the beds full. You have to keep the apartments rented. So, for the pro se who's going into the courtroom, you're going to be dealing with, in the appeals process, judges who are appointed for life or judges who can decide constitutional issues. When you're dealing with administrative law judges at OSHA and EPA and traffic court, etc., these people don't know nor do they understand. IRS, casting your pearls before swine to even talk to them. But it's extremely important that you make the demands. For instance, when you go into this IRS hearing, have you brought your records, Mr. Jones? Well, before I make any admissions and confessions, sir, I'm going to need a definition of what it is you want. Well, I want your records, you dummy. Now, they won't call you a dummy, but, you know, they're going to sit there and say, well, sir, you know what records are. Sir, if I knew what the records were, I wouldn't have asked you. Now, what is it that you're looking for? Well, we're looking for checks, canceled checks, bank statements, payroll journals, and they'll go down this long list, a check register, and oh, okay. Did you bring those, Mr. Jones? No, I didn't. Well, why didn't you bring them? Well, I don't have any of those. Well, what do you mean you don't have any of those? Well, let me tell you again. I thought you asked me plainly if I had checkbook, payroll journal, bank statements, check register. And I thought I answered you plainly when I said, no, I don't have any of those. Why are you badgering me? That's the judicial method of dealing with a question. Now, the layman's method of dealing with the question is, have you brought your records? No, I'm not bringing any records in. I don't have any records. And I don't keep those records. And the checks and things like that, you know, I burned all those, and I don't have any of those anymore. I got rid of all that. And my accountant's got some other things, and I fired him, and I don't know where he moved to. say a layman makes excuses for his actions, or he tries to cover them up, or he tries to evade the question. You talk to a judge the way I talk to judges and learn from judges. They answer questions specifically and absolutely. And you're going to learn to answer questions specifically and absolutely. And what isn't answered specifically and absolutely then comes under the Fifth Amendment and under the Exclusionary Rule. Because the guy says, did you bring your records? Am I a person who is required to keep these records? Would you please bring me a statute, law, rule, regulation, and show me that I'm a person required? Answer questions with questions. You know, I can hold a conversation, drive people crazy. I can sit there, and I was out in court the other day, and don't panic now, I'm not forgetting the Exclusionary Rule, but I want to spice this up for you so you don't sit there and bored to tears. I went out to court the other day, and there was a young lady out there, and she said, Mr. Gordon, are you going to bring those back? Isn't that an insane question? I mean, bring those back. Bring those oranges back, the grapefruit back. Bring your shirt and laundry back. I'm in a court. I'm in the clerk's office. So I asked the question. Here's the way you answer the question. Did I know what she was talking about? Certainly, I knew what she was talking about. I knew what it was she was missing, or at least I had a good indication. You know, I'm a little street savvy. I asked this question in response. I said, let me ask you a question here. Bring what back? Well, the tickets. Oh, tickets? Did you want me to bring you some tickets to the Boise State game, or did you want tickets to the Rose Bowl? Mr. Gordon, now, you're just playing games, sir. Playing games? No, I'm not here to play games. I'm here to file paper. Now, what I want to do is I want to file these two motions. Okay, I'll file these for you, but, you know, you've got me in a lot of trouble. This girl's pregnant. Sweetheart, I didn't get you in trouble, and I don't want you to make those kind of allegations and insinuations. She blushed, chuckled a little bit. Okay, now she starts to file these papers, and she says, you know, Judge Woods is really angry with me because I don't have those two tickets that he gave you, and you were supposed to take them to the marshal, and you didn't take them to the marshal, and you've got them, and he wants to know if you're going to bring them back, or they're going to file felony charges against you for grand theft. Oh, wait a minute. Now let me see if I understand your position here, sweetheart. Have you lost some tickets? Mr. Gordon, you know the two tickets that you were in here on last Friday. Oh, last Friday I was in here. That's right, and I think the record will clearly reflect that I was here. Did you check that file cabinet right over there? Are you sure those tickets didn't fall down in behind there? Have you searched all over for those? They're not there, Mr. Gordon. We know they're not there. Did you check with Marshal Riggs, and did you check with Sam Spade over here? No, nobody has them. Do you have those? Who told you that I had those? Well, Judge Woods said so. Were you in the courtroom that day, hon? No. Did you see Judge Woods physically hand me any of his property? No. Well, then what you're telling me then is hearsay and innuendo, isn't it? Don't you ever give a straight answer, Mr. Gordon? No. In the entire conversation, I never made any admissions or confessions. I'm pretty sure in my own mind what she's talking about. She's pretty sure in her mind what she's talking about, but her total lack of capability, her inability to communicate on a judicial level, left her with no answers. Mr. Gordon, here's the way that conversation should come down. If I wanted to know something, the question is, Mr. Gordon, did Judge Woods hand you two tickets numbered 75287 and 75288 on the 13th, which was last Friday? You know, that's a direct question. Well, sweetheart, let me ask you this. Of what relevance does that have with the business we have today? Well, those tickets are not in our files, and our information leads us to believe that those tickets are in your possession, and if they are, we want them back. Are those tickets in your possession, Mr. Gordon? You either have to lie, or you have to tell the truth, or you invoke the exclusionary rule under the Fifth Amendment and use this term. I don't want to answer that question, as it may tend to incriminate me in some criminal prosecution. Therefore, I demand then, as a matter of right, the right to remain silent. Am I in custody or am I free to leave? That's the way you answer the question judicially. Don't answer questions in the vernacular. I don't discuss law with laymen in the vernacular. I discuss law with jurists or laymen in juristic terms. I don't answer direct questions. When I do answer a direct question, I always pause and stop and ask the question, let me see if I understand your position. Let me see if I understand the question. And then I will repeat the question. And when I'm on the record, what I'll do, when I repeat the question, I will change the man's question and use the words that I want to use. And if I can get him to say, yes, that's the question, then I'll answer the question. See if I can think of an example. Mr. Gordon, do you have the 2 tickets? Let me see if I understand your question. Are you asking me if I stole some property that belongs to this court? Yes. The answer to that's no. I didn't tell him that I had the tickets or didn't have the tickets. You see, she's trying to find 2 tickets. What's the subject matter? 2 tickets. They don't have them. Did they lose them? Did they throw them away? Did I steal them? Did I lose them? Did I throw them away? Did I give them to somebody else? Did the judge hand them to a third party? Did the third party hand them to me? Did the third party hand them to somebody else? We don't know. Those are called contested issues of fact. We're not even discussing contested issues of fact. There's a direct question. Do you have those tickets? I don't want to answer the question yes or no, and I don't want to put in the exclusionary rule. I don't want to use the Fifth Amendment. How do you handle it? Rephrase the question. Get your antagonist to answer yes and then answer his question. The courts do exactly that. Now let me illustrate that, because this is the way you want to train yourself. In a case called Williams versus Florida, a man asked this question. This was called the major federal question of that case. Does a 6-man jury violate the due process clause of the 14th Amendment? Byron White answered the question. No. Conviction sustained. Go to jail. Do not pass go. Do not collect $200. The man's problem was he asked the wrong question, and the justice gave him the right answer to his wrong question. Judges understand judicial questions. It's the laymen who don't understand judicial questions, and laymen who do not know how to converse in judicial terminology. Judges, before they make answers, will always rephrase the question or answer the question with a question, so that when you go through the transcript and the subject matter comes out, you can always substantiate your position. I don't take oaths, and I don't testify. When I want to testify, I testify by affidavit. That way I can't be cross-examined on my statements. That way I can make a statement, I can make an assertion that would require sworn testimony or a sworn affidavit in contravention of my statement, but I can't be cross-examined so that they can get the facts from me. You don't get facts out of me. And they're not going to get facts out of you. Now let's look at the definition here of the exclusionary rule, which begins in 1876 with a string of cases beginning with Boyd versus U.S. The exclusionary rule, Black's Law Dictionary. This rule commands that where evidence has been obtained in violation of the privileges against or guaranteed by the U.S. Constitution, the evidence must be excluded at trial. That's right. When evidence is gained illegally or unlawfully in violation of the constitutional guarantees. What are the constitutional guarantees? Remember? Unreasonable search. Who determines what's reasonable and unreasonable? Supreme Court. How? In Supreme Court cases and decisions. That's what determines whether or not the evidence can be used against you. So here's what you do. You're at the scene of the crime. I'm in the court. I'm talking to a lady. She assumes that I have these 2 tickets. They're assuming that I've stolen them. I'm not going to make the admission, yes, I've got them and I stole them and I'll bring them back. Or, no, I didn't steal them and I don't have them, but I know who does have them. Or, yes, I inadvertently and accidentally put them in my shirt and walked out and I'll bring them back. Those are called inculpatory or exculpatory statements. A crucial thing for you to remember is when you deny something, it can be just as damaging to you as when you admit something. You see, to make the statement, no, I don't have the tickets and I don't know anything about them, could be a lie, and if there's 2 or 3 people standing around, those people can testify as to everything they've seen, heard, and know. I don't want people testifying against me, so whenever there's 2 people present, I don't answer questions. When there's 1 person present, it becomes a contested issue of fact as to whether I did or didn't say it. And since I like to play the game, I don't play the game by lies, because remember, thou shalt not bear false witness. And so, while I don't have to lie, I don't have to say anything. And I got that from Christ. You know, when Pontius Pilate was asking Christ some questions, he remained silent. He didn't answer. He exercised his Fifth Amendment right to remain silent. He said, well, are you a king then? He answered the question with a question. Just take a look at the Gospels and see how Christ answered questions. He never got a straight answer out of him anywhere, at any time. You have said that, or it's been said that. You say I'm a king, Pilate. See? So we learn from the examples of others. That's the way the judicial system works. When Byron White answered the man's question, he said no. Just that simple. In a footnote later, he said, I perceive that the question that the defendant wanted asked was, how many jurors does it take to make a common law jury? Then he went on with this comment. That question is not before the court. But if that question were before the court, we would answer it. Yeah, that's right. The Supreme Court knows how many people it takes to compose a common law jury. The Supreme Court knows and understands what an admiralty jury is. The Supreme Court knows and understands administrative and procedural law versus constitutional right and due process. But the layman who asks the question and doesn't ask the question correctly will get the right answer to the wrong question, and it's do not pass go, do not collect $200, and go straight to jail. Let's go on. Evidence which is obtained by an unreasonable search and seizure is excluded from evidence under the Fourth Amendment. The U.S. Constitution, and this rule is applicable to the states by the 14th Amendment. State courts, federal courts. Exclusionary rule applies in the states as well as in the federal courts. And that comes from a case called Matt versus Ohio, 367 U.S. 643. You want to look at exclusionary rule, take a look at the Matt versus Ohio case, 367 U.S. 643. The court will say, this is the way we've determined this. Now, in Bouvier's Law Dictionary, which is, by the way, an 1870 edition, we use this exclusively, and when you're looking at words and definitions in any of our briefs and papers, they come from Bouvier's 1870 or Bouvier's 1914. There's an important reason for that. Did you notice here, these people go to law school, and the people that write these dictionaries, they sometimes don't understand words in constitutional law themselves. Did you notice that this rule commands that where evidence has been obtained in violation of the privileges guaranteed by the U.S. Constitution? Privileges? I don't act in privilege. Take a look at the word rights and the word privileges. They're just about as opposite as black and white. A right is inalienable. I have a right to due process. A corporation has a civil right or a privilege to due process. That privilege can be suspended at any time. A company acts in privilege on the road. They act in privilege. Your kid can go to the movie next Saturday as a matter of privilege. That's not a matter of right. He breathes as a matter of right. He goes to the movies as a matter of privilege. You can suspend his movie privilege. You cannot suspend his right to breathe. You understand the difference? So here's Black's Law Dictionary, and it says that when you're talking about privileges guaranteed by the U.S. Constitution, I don't act in privilege, I act in right. Take a look at rights and privileges, and just see if whether or not what I'm telling you isn't true. Now, Bouvier's Law Dictionary is available for $150. This, by the way, is a 2-volume set, which is absolutely indispensable. If you're serious, you need it. These are not in print and they're not available anywhere. What we had to do was to copy these ourselves. These are printed and bound by those of us here at the school, and that's probably why they're so expensive. In 1870, these sold for $12, and there was only 1 volume, but because of the paper we used, it took 2 volumes. Now, I'm not telling you that you have to buy them. They cost us about $135 or $40 to make. I'm just telling you, these dictionaries are approved by Congress in 1870 as the official definitions of words from the Constitution of the United States. Another important fact. Law is determined by the definition of the words at the time the law was enacted. So when we're talking about the Federal Reserve Act of 1913, we want to go to Bouvier's Law Dictionary to look at the word income, source. We don't want to go to Black's Law Dictionary of 1974 to look at income and source, because you see the way income is defined today is totally different than the way income was defined in 1913. And the Supreme Court and the higher courts, all of the appellate courts, are going to act based upon the definitions and another thing called the intent of the legislature. So what you're talking about when you're talking about intent is, what were the hearings about? Who said what to who, when? What was the testimony? What did the Congress intend when they passed that law? Who was that law intended to regulate? Is it a law that regulates rights or privileges? The law may be unconstitutional, or it may be constitutional in some of its aspects. So here's another thing then that you have to ask. The intent of the legislature is the law. It may not be worded in the actual statute the way it is intended by the legislature to be applied. Now that really throws a monkey wrench into law, doesn't it? You see, the layman, he goes out and he says, well, all persons must get a driver's license to operate on the road. That's what our law says. Well, now, let's see now. All persons? Well, can the legislature pass a law that regulates a right? No. Remember Marbury versus Madison. That's a very important case, and we're going to talk about it. Marbury versus Madison identifies the Constitution of the United States as superior document, and statutes, rules, codes, regulations, etc. are all inferior to the Constitution. Once you've established that driving on the road is a right, and that comes from a case called Crandall versus Nevada in 1867, and that the right cannot be taxed, Hale versus Hinkle, about 1915. So you cannot tax a right. The power to tax is the power to destroy. We can destroy corporations. You can't destroy citizens of natural and inalienable rights. So you start to build a framework of basic foundational constitutional concept and law. I didn't make those. I'm just telling you that's the way it is. It may not even be good, but it's not important as to whether it's good or bad. That's the law. Right or wrong, that's the way it is. You cannot tax a right. Is a driver's license fee a tax or a fee? It's a tax, so says your Supreme Court. So is the registration. So Crandall, then, absolutely forbids the taxing of a right, and yet your legislature has passed fees pursuant to driver's licenses and made a statute that says all persons must have a driver's license. Now, either one of two things. That statute, Idaho Code 49317, is unconstitutional, or it's unconstitutional as it's applied to me in my case. So mark this down and mark it well. Never attack the constitutionality of a particular law. Because I can tell you right now that that statute passed by our legislature in 1914 requiring all persons to have driver's licenses is not unconstitutional. Because there's a thing called an enabling statute. That enabling statute is right up at the beginning of Title 49. And it identifies the classes of persons who are required under that title to have driver's licenses. So based upon the enabling statute and the power of the legislature, which is to enact law, rules and regulations pursuant to trade, commerce, business, and industry. The legislature cannot enact laws that affect rights. Look at Miranda, page 491. Where rights are involved, there can be no rulemaking or legislation that would abrogate them. Now listen to this carefully. This is the way the Supreme Court is going to see this. This is the way the Supreme Court rules. This is the way the law works. A group of people want legislation. Why do they want legislation? Because they want to make money. People don't go to the legislature to get laws passed if there's no incentive or nothing in it for them. So it's either the insurance industry or the labor unions or it's the public employees or somebody. They go up there to pass law. Pass law concerning who? Well, if it's the doctors, then they want to pass laws that restrict competition. They want to get rid of the nature paths. And if you're talking about labor unions, then they want legislation that protects them against the open shop or right to work bill. And if it's the National Association of Manufacturers, then they want a open shop or a right to work bill. You see, these people want certain legislation to benefit them financially. I don't know of any other exceptions. There may be some, but listen, 99% of the time it's going to be money-oriented. All right, so now, the legislature, then, what are they there for? They're just there to represent the will of the masses of people. You know, if they think that 51% of the people want something or that 51% of the people don't object to something, they'll pass whatever law you want. A lot of those legislators aren't lawyers, they're not constitutionalists, they're just laymen. They haven't got any idea about law, and they couldn't go in the courtroom and argue a case any better than you could. Our legislators here get caught for drunk driving, and they just go in, plead guilty, and walk out, and the fools are up here passing drunk driving legislation. You'd think, if nothing else, they'd think of their own self-interest and say, I'm not voting for something that's going to come down on me and create a police state around my own little world. All right? That'd be my common sense reaction to that. So, the word all persons does not mean every last citizen in the United States. It only means all persons who come under the purview of the enabling statute of the particular title that's in question or that is the subject matter of the law. That's all that means. Let me illustrate that to you. Did you sign up for the draft? Well, look at me. I didn't. Did you sign up as a resident alien? I didn't. Now, what if the policeman comes up to me and says, Sir, did you sign up for the draft? Did you sign up in January as a resident alien? Are you violating Title 42, Section 1927 of the U.S. Code and Section 27 of the Idaho Code, Section 2204? Let me see, officer. First of all, let me put up the exclusionary rule here. I don't want to answer your questions Am I in custody? No. Goodbye, I'm leaving, and I walk away. Yes, you're in custody. You can't leave. Oh, well, if I'm in custody, then I don't want to answer your questions. I demand counsel present, and what's your probable cause for making this intrusion into my life? I'm going to hang him right there. I'm not even going to talk to him about the subject. I don't have to talk to policemen about whether or not I'm an alien or a resident alien, or whether I'm born in Brazil or born in California. It's not relevant. I don't answer questions. Let's talk about Brown versus Texas. You know, when we get to Brown versus Texas, do people have to identify themselves? Absolutely not. I don't have to tell you my name or anything about me at any time. You have to have probable cause to believe that I am something other than. You, the policeman, have to have probable cause to believe I'm a convict, or that I'm escaped from jail, or that I'm a resident alien, or something else. I don't have to talk to you at all. I don't even have to answer your question. What's your name? But as a matter of practical fact, I always want to put the exclusionary rule up and make those three demands. Counsel, I don't want to talk, and what's your probable cause? Because that establishes this exclusionary rule. Now, whatever he gains from me is illegal and unlawful, and I can have it excluded from evidence. Now he can't use it against me. Everything that you say can and will be used against you. And put another way, all of the evidence that the government uses against you will be furnished by you. Now let me tell you about the story of a fellow that just came in here not too long ago, charged with drunk driving. This fellow had a couple of beers, went down to Perkins Cake and Steak. He sits in there for 4 hours with some friends and he leaves. On his way home, policeman stops him and asks him the question, hey, I saw you weaving on the road. Is there any reason for that? Well, see, there was a chuck hole over there, and that's why, and blah, blah, blah. You've been drinking? Well, I had a couple of drinks earlier in the evening, and couple of drinks? How many more? Well, maybe, I don't know. I didn't count them. Maybe I had 4 or 5 beers. That was earlier in the evening. You're under arrest for drunk driving. You see how the admissions and the confessions can be used against you? There was no probable cause to believe the guy was drunk because he dodged a chuck hole. There was probable cause to believe that he was drunk as soon as he asked the man, have you been drinking? Yeah, I had a couple of beers. Well, the officer doesn't know how long ago. Was that 15 minutes ago that you had 2 beers on top of 6 martinis? And so the officer then, being a part of the law enforcement growth industry, trying to rid our streets of drunk drivers, just jumps to the natural conclusion that, well, this guy's a drunk, so I'll haul him off to jail. And besides that, it's been a slow evening tonight, and I've only made 2 contacts, and I need more contacts. And by making an arrest and taking him to jail, that'll make up for 4 contacts, because you only have to make 2 arrests per shift. You have to make, I think it's 4 to 6 contacts or 8 contacts per evening. You see, the policeman has to justify his existence. They just increased the police force by about 5% and their budget by 5%, and so they've got to pick up 5% more criminals. Now, the citizen then is at a real disadvantage because a lawyer wants about $600 to $1,000 to defend this drunk driving charge, and the government, that is the court, only wants $150 for this guy to plead guilty. And so the first time a guy just says to himself, economics tells me I'll pay the $150 and I'll just be careful and not get caught. Unfortunately, the guy gets caught a second time. In Idaho, it's a felony. He's not guilty the first time, but he's pled guilty, and so now there's his record established. You see how important it is? In every case, if it's important enough for your government to prosecute, it's important enough for you to defend. Now, I have 33 actions against me. At this moment in time, there are only, well, I should say now there's 35, because 2 civil contempts were issued against me and are at this time still unresolved because I'm in the process of writing an appeal to the Federal Supreme Court. If that last appeal fails, I'm going to have those 2 criminal convictions entered against my record. But in 5 years, I don't have any convictions against me. Oh, a lot of arrests. One policeman the other day said, Gordon, you got the longest rap sheet I've ever seen. So what? All that means is that my government continually harasses me and abuses its power. That's all that proves. Well, ordinary citizens don't get arrested this many times. Ordinary citizens don't demand their rights. Ordinary citizens are sheep, and ordinary citizens come in to be shorn. I don't. When a citizen exercises his rights, it's going to separate him from the rest of the sheep. And he's going to look like a criminal. And the policeman, he looks at you and says, hey, you've been arrested all these times. Policemen assume that arrests are convictions, because if a policeman makes 10 arrests, he can just about bet that all 10 of them are going to be convictions. And that's just the way the system works. And I don't know if it's right or wrong or good or bad, but that's the way it works. All right, now what I want to do next, pursuant to this subject matter of exclusionary rule, and this is a long lesson, and I've divided it into 2 lessons and split them up. I want to talk to you a little bit about this thing called attorneys and counselors at law. You need to understand right off the bat that the court is going to intimidate you, in the traffic courts and the lower court. They are going to intimidate you something awful. I went into a court one time, and the judge didn't know how to handle me after the first, second, third, fourth time. I'm in there pro se or in propria persona, and I'm demanding my rights and et cetera. And she says, Mr. Gordon, it's obvious that you don't understand the procedure of the court, and therefore I'm going to appoint for you the public defender. Well, Your Honor, I object. And she came down, she jumped up off the bench. If you utter one more word, I'm going to hold you in contempt. Now, you have to be careful of the contempt powers of judges. If you'll look in the Green Book, the one that says legal quotations, out around 300 where it talks about contempts, take a look at the 3 or 4 Supreme Court cases on that. Fisher versus Pace, I think, is the key case in what's called civil contempts, or criminal contempts for that matter. When the judge threatens you, remember this. If you're asking a question, that's not contempt of court, but a direct statement can be interpreted as contempt of court. So when you're in a courtroom, very seldom should you make direct statements. You should always be asking questions. An example of that works like this. Now, she just laid down the law and said, if you even utter another word, I'm going to hold you in contempt of court. Okay? Don't utter another word. It isn't necessary. She's already committed reversible error. At that moment in time, I had that case won. We're in an arraignment. But you know, the average layman would say, well, she's oppressing me and she's violating the law. She can't appoint a defense attorney for me against my will and over my objection. Sure she can. She doesn't have to obey the law. She's got free moral agency. She can break the rules anytime she wants. Help her. I shut up right then. Why would I want to tell her, gee, Your Honor, I think you're making a mistake in committing a felony here, and I think you're going to be... Well, then she'd just get mad at me and throw me in jail, wouldn't she? So you just sit there. And pretty soon she got through with her diatribe, and she said, now, do you understand what I'm doing, Mr. Gordon? Mr. Gordon, do you hear me? Mr. Gordon, are you trying to be insolent? Are you going to answer my question? Are you going to hold me in contempt if I answer your question? Remember, that record is turning round and round. She threatened me with contempt of court if I so much as opened my mouth. Can a judge in a court tell a defendant that he can't defend himself? You know, the question is absurd and insane. This poor lady is a lay judge. She's not an attorney magistrate. She doesn't understand law. I walk in her courtroom. I lay a heavy trip on her concerning rights and law. She doesn't know how to deal with me. She loses her composure. She comes unglued, and she commits error. I've already won the case. I don't care what she did. You see the way you deal with a fool? You just deal with the fool with reason, logic, and common sense. Are you going to punish me if I defend myself, Your Honor? Are you going to hold me in contempt of court and put me in jail if I put on a defense? Are you going to charge me money if I demand due process of law and equal protection? Are you going to put me in jail without counsel? Are you going to put me in jail in violation of Argersinger versus Hamlin Sheriff? Now, I'm not saying that you're going to get all of those questions in at any given time, but you need to read Argersinger versus Hamlin Sheriff, and you need to read Carroll versus U.S. Remember what I told you earlier. When you read cases, goes into your computer. Now, I don't even remember the citation on Argersinger versus Hamlin Sheriff, but I'll tell you this. The Supreme Court of the United States said, quote, that every misdemeanor case, every judge in every misdemeanor case will know from now on, so there's no doubt, that counsel will be afforded the defendant or no jail, period. You cannot be put in jail without counsel. And in Idaho, they won't let you have counsel because they're afraid of breaking up their union monopoly. So I walk in the courtroom, we have numerous briefs and motions on the counsel issue, we demand counsel of our choice, next friend, Powell versus Alabama, lay it out in spades so that nobody can misunderstand, and you can't put me in jail. And if you do, then I'll sue you under Title 42. That's the way that comes down. Now, you need to be aware of the intimidation that's going to come down on you and to have some background and knowledge. See, where you're at, you don't know whether the judge can put you in jail or not. But once you've read the Argersinger case, there's no doubt. Bear in mind that judges, policemen, jailers, these people break the law, violate the rules with impunity. In fact, they don't even know what the rules are. One of the first things you need to do in whatever county you're in is to look up your judicial district rules. And there's 3 sets of rules. Now, you've got your Idaho criminal rules, the Idaho rules of civil procedure, and the Idaho misdemeanor rules. Okay? 3 sets of rules, and those are published, and they're going to be in your Idaho State Code. Then there's one more set of rules that nobody tells you about. See, only the lawyers and the judges know about them, and they're called your district court rules. Every district court, to my knowledge, nationwide, has the rules, and those rules are up in your local law library. So watch what happens. You demand the local district court rules by motion. You write up a motion. When we get to the lesson on motions, I'll show you how that goes. You write up a motion and you say, I've got to have those. And the court doesn't give them to you. Now, how can you go forward without the rules of the game? You see how you change the charge from speeding to deprivation of rights on appeal? There are so many rules. We estimate here in Idaho about 800 rules that these judges, jailers, prosecutors, and people have to obey and observe. First of all, if they knew of all the rules, I don't think they could do it. And if they violate your rules, remember, you have to be able to identify the rule that they violated. Failure to object or failure to assert a right is fatal or waives the right. If the judge doesn't know about Argersinger, and you don't tell the judge about Argersinger, and the judge puts you in jail, the judge has committed a violation of your civil rights, and under Owens v. City of Independence will be held liable if you sue him. But it really weakens your position if you don't tell them in advance. What really strengthens your position and shows a thing called malicious intent is when you tell the judge, don't do this because you will be breaking the law if you do, and then they go right ahead and do it. Take a look at malice in a legal dictionary. Willful intent to deprive a person of his rights is a crime. Now do you see what you've done? He hasn't done it ignorantly. He did it with malice and premeditation. And it's crucial that you be able to prove intent. Because remember, a crime consists of 2 elements. That is, the action and the intent. So, when you're going to sue the judge, the reverse is just as true of you as it is of the policeman and the judge. You see, they have to show that driving 80 miles an hour is a crime, that there's a victim, that there's a loss, that there was intent to break a law. In Idaho, that's Idaho Code 18-201. Now, in your state, it's going to be something other than that. And it'll be up to you in your state and in your county, whether you're in Oklahoma or Texas or wherever you are. You've got to look those up. You've got to do a little homework. You've got to go into a law library and sit down and learn how to use that law library. And I'll explain how that goes as we go along. What I want to warn you about now is this. When a judge appoints counsel for you, you must object. And here's why. Once the attorney is admitted to the case as the attorney of record, he has your power of attorney and you're declared incompetent. What he does for you is being done with your permission. You must object timely. So here's how that comes down. Mr. Gordon, I'm going to appoint Klaus Wybe, the public defender, to appoint you. And if you open your mouth, I'm going to hold you in contempt of court, and you take this order down to Klaus Wybe and blah, 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 etc. I didn't say much that day. I left. Then I wrote up a motion to dismiss Klaus Wybe as a violation of due process and equal protection and a violation of Zerst versus California. And I filed it with the court. This was a fun issue. I'm telling you, you're going to have a ball with this. Now watch how this one came down. I filed the motion. There's my disclaimer. And you must make a disclaimer if you don't want something. You've got to make what's called a good faith effort. So I made my good faith effort to the court, good faith effort to the prosecutor. I said, I don't want that. You're compelling something upon me I don't want. You're trying to compel a contract upon me in violation of Article 1, Section 10. And my right to contract, my right to defend myself are inalienable. So I wrote up 154 questions. You know, as an employer, I have always had a checklist. When I'm going to employ somebody, I want an accountant, I want a lawyer, I want a bookkeeper, I want a secretary, I want a millman or a pressman. I don't care what the job is. Don't you ask the fellow, well, what's your name, and how many years of experience have you had, and what kind of success have you had? And so I wrote up about 154 questions, I said, and I went in. This court order said to go to the office of Klaus Wybe, or I had to call him. So I called him on the phone, and I said, hello. Hey, my name is George Gordon, and I need an appointment with my public defender, Mr. Odyssey, I believe the name is. Oh, yes, Mr. Gordon, we're going to schedule that for 9:30 on Thursday. Is that acceptable? Oh, yes, that's fine. Thank you very much. Bye. Hang up the phone. Got your appointment, right? I went over and I got 3 friends for witnesses, and I took my 154 questions, and I walked in, trip, 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 trip. Gosh, hi, my name's George Gordon. Now, don't get nasty and surly because this is being compelled upon you. You know, the average guy'd say, I'm not going to sit still for this, and I've about had it, and blah, blah, blah. See, that tends to demonstrate your incompetence because, you see, you've lost your composure. Always keep your composure. If you're not having fun at this, you're not doing it right. When I go into the IRS, I have fun. IRS people don't interview me, I interview them. And that's the way this comes down. See, the average Joe Schmuck goes into his public defender, and the public defender interviews him. Well, when did you rob this place? How did you break in? Did they catch you with the tools? That's the way the interview goes. Okay, they've charged you with DWI, so you were drunk. How many beers did you have, and where were you drinking? And see how that goes? I walk in. Well, Mr. Gordon, I see here from your file that you've been charged with driving without a driver's license, no registration, and proof of insurance. Is that the way that comes down? Let me ask you a question here, Mr. Odyssey. I don't want to be rude, and I don't want to be obnoxious. And I want you to understand my position before we get involved. I went into court the other day, and this judge ordered me with this court order to come here and see you. And I want you to know and understand that I like you, and I think you're probably a very nice man, and you're probably very competent and very capable, but I don't want you as my attorney. I don't want you to handle my case, and I want you to butt out of my life. Well, Mr. Gordon, gosh, well, you know, here's going blah, 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 blah. Probably the first fella in that guy's entire legal career to ever come in and say, I don't want you, and you're being forced upon me against my will and over my objection. They'll do that to you. And there's an important reason, because they know and understand that the Supreme Court has said you can't go to trial and you can't be convicted without counsel. I'm not saying lawyer, I'm saying counsel under the Sixth Amendment. There's a big difference between a counsel and a lawyer. All lawyers are counselors, but not all counselors are lawyers. The Constitution mandates counselors. There's a difference between a counselor and a lawyer. I'm a counselor. I am not a lawyer. And don't you call me one either. All right, so here's this poor lawyer. He's sitting there going, well, what are you doing here, Mr. Gordon? I came here to interview you to determine whether or not you're competent to handle my case. Let me tell you, if you don't think that brings the conversation to a close, why, he almost came out of his seat. Now, see here, Mr. Gordon, just who do you think you are? You know, I challenged this poor little fellow's authority. I had called into question his ability and competence. Here I am, the citizen and the layman. I'm one of these dumb schmucks that he goes out to the jail to interview, to guide through the legal process into jail, and all of a sudden I'm coming here with my questions and I'm saying, sir, I'm here to interview you to determine whether you're competent to handle this case. Mr. Gordon, all this is a simple traffic case. What are you trying to make out of this? Well, one of the things that I wanted to ask you about was how serious you would take this simple traffic case. Because this simple traffic case is an affront by my government to my liberty. And I believe that anything that my government is serious enough about prosecuting is certainly serious enough for me to defend. I want to win. And I'm not here because I need you or I want you. I'm here because the court ordered me to be here. And I brought these witnesses with me because in the event that you're involved in a conspiracy with this court to deprive me of my rights, I want to inform you before you commit that act that I'm going to hold you responsible and I will prosecute you criminally and civilly to the fullest extent of the law. May we get on with the interview, Mr. Odyssey? Absolutely not! I'm not going to be interviewed by you or anybody else. I mean to tell you, this poor guy just lost his composure. Oh, Mr. Odyssey, if you'd like to take a few minutes to regain your composure, we're certainly willing to wait. I mean, when I said, you know, you could go out and come back in when you're finished with your temper tantrum, he got up and he said, "This interview is terminated!" And then he called for a secretary and this guy just threw me right out of his office. So I walked out and I turned to my witnesses and I said, my goodness, I don't think I want to hire him. I don't think his attitude is right. And I don't think his qualifications for the job really fit this particular kind of crime. He's probably a very good defense lawyer for murder and rape and robbery and crimes like that, but it's pretty obvious. Wouldn't you agree with that, Martha? And don't you think that's probably true, Bob? See the way you deal with a fool who can't keep his temper, and he just kind of, you know, he's a nice guy, and I went in there and I made an ass of him, and he didn't like it. And did it in front of my friend. Now we go back out to the court. Now we walk in, trip, and here we go a week later. Well, Mr. Gordon, Mr. Gordon, I didn't call the court. I didn't tell him that I wasn't coming out with Mr. Odyssey. I didn't tell Mr. Odyssey not to appear in court. I just verbally fired him, and well, really, I just kind of verbally didn't hire him, now did I? So I go out to the court, and here's the judge, and she says, I ordered you to go to Klaus Wiebe, did you? Oh, yes, I did, Your Honor. Here's your court order. And I went down to Klaus Wiebe, and I went in to interview him, and he got angry and threw me right out of his office. maybe you should appoint another defender or something for me to interview. Because he really got mad, and I came here today with 3 witnesses, and I'm prepared to put those 3 witnesses on the stand and testify either orally or through affidavit that I complied with the court's order explicitly. See the way you deal with a ding-a-ling? Don't sit there and get mad and jump up and down, rant and rave and scream you're violating my rights. Do you have another court order, Your Honor? Would you like me to go down and interview another public defender? I'll interview public defenders until there are no more public defenders left in the United States, and if I find one that I like, I might accept it. I didn't say I wouldn't accept the guy. In writing, I said I don't qualify because I'm not indigent. And in this state, you have to be indigent in order to qualify for public defender. So number one, I said, gee, I could hire F. Lee Bailey if I wanted him. The only reason that I don't hire F. Lee Bailey is that Lee just isn't qualified or competent to handle these types of cases. I mean, no hard feelings, Lee. I'm just telling you, I don't think you're qualified to handle traffic cases. I am. Well, here's the way the case came out. The prosecutor just dismissed. We never went to trial. I don't even think we went to a motion hearing. I filed 10, 15, 20 motions. I don't know how many motions I filed in there. That was my first experience, and that's the last time in Ada County anybody tried to appoint a public defender for me. I don't care. They can appoint a public defender for me every week. Yeah, that's funny. I have my 154 questions. I keep them with me all the time, and I'll just go right in there and interview my public defender, and then if I determine he's qualified, I'll hire him, and if I don't, I won't. What you have to be aware of is that not just this example of an abuse can transpire, but something else may transpire. Maybe they'll order you for a psychiatric evaluation. Well, you know, they can do that. They can throw you in jail for 24 hours and then order a psychiatrist. How are you going to deal with a psychiatrist? Well, I don't know. I've never had them do that to me, but one of these days they'll probably try to lock me up in Blackfoot and claim that anybody that demands these rights has got to be some kind of a nut. So what you do there, in my opinion, I just kind of go in, hi, doctor, do we have the doctor-client privacy relationship guaranteed under the Constitution by the highest law of the land? Can I talk to you privately, or are you going to report this back to the court? Doc, I don't know if I want to talk to you or not, and I'll tell you why. You're probably a nice man and all that, but I don't think I want to divulge any incriminating information or evidence. What I want you to do, doctor, I want to demand all of my rights at all times, and I want a public hearing to determine my sanity. And I demand the right to produce witnesses and evidence, and my own private psychiatrist to determine whether or not I'm competent or incompetent. And if you're put into that kind of a situation, you may have to work on it. Avoid lobotomies like the plague if you possibly can. You know, in the Soviet Union, they used this kind of terror by using lobotomies and by putting people in mental institutions. I'm not so sure, but what that isn't done from time to time here in the United States. So you'll have to deal with it wherever you are and whatever circumstance you're in through reason, logic, and common sense. I wanted to bring that to your attention because it could occur, could happen to you. All right, forewarned is forearmed. Now, I want to start here with a case called United States Supreme Court versus Terry, and this is an Ohio case, and I'm going to take you through this Terry case at some length for the purpose. Not that Terry is necessarily a crucial case in constitutional law. But everyone has to start somewhere by being introduced to the Supreme Court and the way the court rules and the way the court makes decisions.